So I'm very pleased to be able to introduce our first panel of the day, one of the topics where we've had some really good interactions with policymakers, and I think due to the efforts of my colleague John Hollway, been able to produce some groundbreaking research is in the area of conviction review. And so John is going to lead a panel where we discuss a little bit more of the issues around conviction review and conviction review units. So take it away.
Thanks, Paul. Yeah, as Paul said, the topic of conviction review units is something that we've been interested in for some time. Since, well, depending on who you talk to, Dallas or Santa Clara started the first conviction review unit in the late 2000s, the aughts, I believe that decade is called. Conviction review units have really been spreading rapidly across the country and gaining momentum. We published a report in 2016 in which we did fairly detailed interviews with 21 of the then 25. Since that report, there are at least 10 additional units that have been created, mostly in metropolitan areas around the country. And whether you call them conviction review units or conviction integrity units, I think they're evidence of a trend in the changing nature of the prosecutorial role and how it's perceived across the country. Because what a conviction integrity unit does, what a conviction review unit does, is it is, in a sense, the prosecutorial institutional response to the Innocence Project. It is a unit within a district attorney's office, in most cases, that has been created to respond to and investigate plausible claims of actual innocence from people who have already received a conviction. So these are people who say, yes, I understand that I've been convicted of a crime. Notwithstanding that, I continue to maintain my innocence. I did not do this, and I need to have an outlet. And our appeals courts are poorly suited in a lot of instances to handle those cases well. And I think it's a really important message that the offices that have created conviction review units send to acknowledge that the obligation of a prosecutor as a minister of justice is a perpetual obligation, and it extends beyond the date of a conviction. It's also important for prosecutors to acknowledge the reality that we talked about earlier, that there are errors in the criminal justice system. And that acknowledgement is not necessarily a statement of misconduct. It's not necessarily a statement of criticism. It's a statement of objective fact that we don't always get it right in terms of guilt and innocence, and the ongoing obligation is to remedy those errors once we find them. So it's both an outward gesture to the community and an important inward gesture to the other prosecutors in the office that the obligation is ongoing, and as a culture, the culture in those offices needs to pay attention to those risks. Now, some offices acknowledge that better than others. On the date that our report on conviction review units was published, there was a conviction review unit that announced its creation, and in the press release, the DA said, "We have never made a mistake. But if we do, now we have a conviction integrity unit to deal with it." And so, there's still, it's a process where people are coming to this. But one of the things that I think are really interesting about conviction review units, and that we have a terrific panel to talk about today, is that the DA role is really a very complex one. We had back when he was the first assistant, now the DA of Montgomery County, Pennsylvania, a guy named Kevin Steele, was here at our very first symposium, and he said something that really has stuck with me. He said, when we have new prosecutors come in our office, and one of the first things we say to them is, "Who do you represent?" And they say, "Well, we represent the victim." And we say, "Well, yes, who else do you represent?" And they say, "Well, the victim's family." And we say, "Who else?" And they say, "The community." And we say, "That's all right, and who else do you represent?" And they usually look at him blankly, and he says, "You represent the defendant." Right? As a part of the community, part of your obligation is to do right by the defendant as well. And unlike, for example, the public defense role, where you have a very clear individual client, when you're in the prosecutorial role, you have multiple clients with multiple perspectives, and a lot of the conviction review cases bring that into very sharp focus, and we'll talk about that today. Because when you've created a conviction review unit, you're communicating to the community, but you have to deal with the victims of the original crimes, and their families. You're communicating with the defense bar who brings these cases, often within a context of skepticism because you're reviewing cases that were within your own offices. And you're communicating back to the prosecutors who represented those original cases, and the vast majority of the time, you know, obviously don't believe that they got it wrong and don't want to believe that they got it wrong, want to believe that everything they did was the right thing to do and with the right result. So we're going to talk a lot about those tensions today and about the structural context of conviction integrity units. And I don't think we could possibly have a better panel to discuss a lot of these topics, because what we'll have is one unit that is starting up, one unit that is rebooting, one unit that is restructured recently, and a defense perspective from a conviction review unit veteran. So let me introduce, actually you guys are perfectly aligned up for my alphabetical introduction, so this is really good. On the far right, we have Glenn Funk, who is the District Attorney General for Nashville and Davidson County, Tennessee. General Funk has been a special prosecutor, an assistant district attorney, a public defender, and a private attorney in his career. Was named the 2014 Man of the Year by the Tennessee Tribune newspaper for his work in improving the diversity within the Nashville DA's office. He's a graduate of Wake Forest and the University of Mississippi Law School. To his left, we have Kathleen Martin, who is the first assistant district attorney here in Philadelphia. She joined the DA's office in November of 2015 after a career as a defense attorney and prosecuting attorney in state and federal courts in Pennsylvania, most recently as an assistant district attorney in Pike County, Pennsylvania. And she's a graduate of Villanova and Temple Law. To her left, we have Rico Valdez from Ware County, Texas, which is San Antonio. Rico is the chief of the appellate division there, where he oversees all post-conviction and habeas litigation. He's been with the appellate division for 17 years. And Rico's all Texas all the time. So UT undergrad, UT Law, there it is. And to my immediate right, we have Mike Ware. Mike is the executive director of the Innocence Project of Texas, started his career as a criminal defense attorney, but spent 4 years, 5 years? 4 years? 4 years. 4 years as the Special Bureau Chief for the Dallas District Attorney. And one of the things that he did in that role was to originate the Conviction Integrity Unit in Dallas, which is widely credited as being the first Conviction Integrity Unit. So Mike really built the plane while it was in midair. And Mike has a philosophy degree from the University of Texas and a degree from Houston Law School. So thank you guys all for being here. And I think what I'd like to do is maybe sort of ask each of you a formative question and use that as a way to get things rolling, and then we'll all talk amongst ourselves and invite the audience to participate. So Rico, why don't we start with you? You recently restructured the Ware County unit. So the Ware County unit has been around for a couple of years, and now you've restructured and changed the leadership. And so can you talk about that process, the decisions, and why you did it the way you did it?
Sure. By the way, thank you for having me here this morning. By way of backstory, prior to 2015, our office did not have a dedicated conviction integrity, conviction review unit. Instead, I was, the post-conviction division chief, and sort of everything worked through me. My lawyers handled both direct appeals and then any post-conviction habeas. When our new DA got elected, Nico LaHood, one of his big things, he was a former defense attorney, and he really wanted a dedicated conviction integrity unit. So we reached out to folks like Mike and other conviction integrity units around the country to sort of figure out what would be the best model. And we structured it so that it would be headed by a conviction integrity chief who would be a senior level felony prosecutor. We wanted someone that had both defense and prosecution experience, as well as some strong post-litigation experience, because it is a different world. We also decided that we needed to have additional support, so 2 junior level felony prosecutors were assigned to the unit as well. And as far as the legal work and actually handling the cases, the unit, I think, has been working very well. We've gotten feedback from defense lawyers, and they're happy with how the unit's being run. Where we were encountering problems was sort of with the administrative aspect of the role. One of the things with a lot of the conviction review integrity units throughout the country is sort of they want them to be separate from the normal prosecutorial chain of command. And so we decided early on, the DA decided that they would basically report directly to him. So the conviction integrity chief reported to the DA, they would make the decisions and go from there. Our office isn't, huge, but we do have about 200 lawyers and multiple divisions. And in handling these cases, it wasn't being communicated to the rest of the office. And one of the things that we're particularly concerned about, and it's the thing you were talking about, John, it's changing the culture. We don't want conviction integrity to just be a back end, something we worry about after someone's convicted. We want them to think about it at the outset. And so having any concerns, some of these, senior prosecutors thinking, well, is this some sort of internal affairs division in our office that is looking that? That's not the way it was supposed to be. That's not the message, the culture we wanted to send. So we looked at year 2 of the administration, and it wasn't just conviction integrity. The DA was looking at all of the changes he made to see what's working and what's not working, because we're not locked in this mindset. We have an idea, let's keep doing it if it's not effective. And in that review, we looked at other sort of special units. We have intox manslaughter, assault unit, we have a public integrity unit. All of those units have one additional layer of administration before the DA, which is one of the division heads. And so when we thought about that, we thought, well, I had the experience with the post-litigation. It made sense to have the conviction integrity chief report directly to me, and then I would be the conduit to interact with the rest of the office, allowing the chief to focus on the legal work and leave all the administrative headaches to me. So that was sort of the impetus for the sort of just restructuring in the chain. We also thought, the original idea had been we will have a dedicated staff and that is all they do. We realized that that sort of isolated them for the rest of the office. We thought one of the better things to do would make the positions rotating positions. The more people we can get through the conviction integrity section, the more that message is going to spread to the rest of the prosecutors in the office. And so we thought, 2 years in, Jay Brandon, our former chief, had done a fantastic job starting it, setting it up. We were looking to see who we could bring in to effectuate that goal. And we had a lawyer, Patrick Ballantyne, who was in charge of our ethical disclosures, Brady disclosure stuff. And he had been working with all the trial lawyers at the front end about this needs to be disclosed, this is how we do our disclosure procedures. So he already had a good relationship with them. We thought we'll bring him in, make him the conviction integrity chief, and start spreading the message that way. And that's what we did.
So one of the things that came up when we were doing our interviews was there are offices that actually felt that the appellate mindset of using procedural and other means to preserve a conviction was at odds with the mindset of a conviction review unit, where you were to be sort of taking a more skeptical eye, from the department's perspective and looking at, is this a plausible claim of actual innocence? Have you found that to be a challenge by relocating it within the appellate unit?
No, but that is certainly one of our concerns. I think partly it's I've never had that mindset when I, throughout my entire career. I've always had a different mindset of how I approach appeals as opposed to how I approach post-conviction habeas. And so I think, that mindset permeates the attorneys in my section. But I do still think it's a good idea to have not the appellate attorneys handling both cases, to have dedicated attorneys whose job is just to do the conviction review, conviction integrity.
So Kathleen, I'm going to use my word, you should feel free to disagree with it, but you're kind of rebooting the conviction integrity unit in Philadelphia, and so presumably you've addressed that same question about where it should sit and what you should do. Can you talk about sort of how you approach the decision to say, okay, I think we want to make changes, what prompted that, and then your process?
The question on what prompts change, I think we're all here to learn and improve. So any kind of change should always be encouraged among all of us because we always want to improve. So not looking back, but looking forward, we had a conviction review unit that was a single person who got pulled away in many directions for other special assignments, big profile cases and whatnot. And having done and started to look at all the research when I first came into the office, I realized much, much more can be done. And in doing so, we needed fresh eyes, fresh face, fresh look, and fresh insight. So that started in our office with doing the best practices research, just like everyone else did, with the Quattrone report, talking to established conviction review units, conviction integrity units throughout the United States, and learning and learning and learning from all of them, and then synthesizing what do we think works there that can also work in our office, because we all have to acknowledge that every office structurally, administratively, and culturally are different. So we have to figure out how it can work in our office. So getting fresh eyes was the first step. So we added more people to it. We changed the director. We have our new director of conviction review in the audience, the assistant director in the audience, as well as the paralegal in the audience as well. And we're a good group of people with open minds and the fresh eyes. And the work they did to gather the best practices, talk to everybody, and then create the protocols. So it's rebooting it by bringing in new people, creating the protocols and the procedures so everything is transparent and accessible. Previously, the unit took only submissions from attorneys. Now we're opening it up. The submission forms are online, and defendants in prison or elsewhere can file on their own, and we're taking in submissions from from them directly. We've gotten 150 letters we've sent out just since we started in January, acknowledging the receipt and looking at their submissions. So the idea is always to improve, and I think it's a living document. All our protocols and all our procedures and consent forms and everything are a work in progress. And I don't think that's a bad thing. I think we all have to acknowledge that as we learn more and gain more knowledge and see what's out there and see what we're faced with on the difficult decisions, that we continue to learn and learn from each other as well as from the Defense Bar, the Innocence Projects, and everyone else. So I think that's important. So rebooting and restructuring hopefully is an ongoing process, and there's no negative connotation to that, and we all just always want to do the right thing.
So you said something that I think is important to emphasize, and certainly that we found in our research, which is that each of these units is a little bit different. And in fact, one of the reasons that we published our research was to show the different approaches so that there was sort of mutual and shared learning. Given that, and given the need to fit something into your culture, is your office, like Bexar County, in the appellate division, or where have you placed it and why?
Yes, thank you for asking. The previous unit was under the law division, which included and had direct report to the deputy of the law division, which includes appeals, federal litigation, PCRA, and civil litigation. We have now taken it out and made it a more independent unit. We will hear what Rico said about the culture and addressing the buy-in from the office. So we did take it out so it's a more independent unit. They don't feel, no one in our unit feels they have to report to PCRA about what they're doing differently than what they did. They don't feel they have to get their approval. We look at it and they make the decision and they bring it up to me and then to the DA himself. But to address the buy-in from the office now that we're separate, I like the idea of rotating, and if we get bigger and we're moving forward, I think that's a fantastic idea. But to get the buy-in, what we decided to do first is monthly, our office has a supervisor training. And so it's the 52 supervisors in the office, assistant chiefs, chiefs, divisional deputies, et cetera. So we did a presentation to them. The director and assistant director did a presentation about what the new conviction review unit is, what our protocols are, how we're going to work, and sort of inviting feedback, questions, and let them know we're there and that we're open to take cases that they may have down at the municipal court level, the waiver level, the jury trial level. Like, we're open to internal submissions as well.
So, Glenn, you're a relatively new prosecutor. You've been in office for 2 years, and you've seen other cities, other municipalities start up conviction review units, and you think, maybe I'd like to have myself one of those.
Well,
Correct. It's a situation where I first heard of conviction review units because I get a weekly email from the Prosecutor's Center for Excellence, headed by Chris Heyman. And there were some articles that she had sent out that discussed conviction review units, not only the one in Dallas, but a case that Los Angeles had handled, and another article about what was going on in Santa Clara, California. And so after reading those, I then got on the internet and found the Quattrone Center's paper and read that, and then went to some of the senior assistants in the office and said, you know, what do you do if you are presented with evidence of actual innocence on a case that has actually gone all the way through the appeals process? And of course, any prosecutor, probably every prosecutor across the country, would say, oh, well, we understand that our job is not only to pursue guilt, but to protect innocence. And so, of course, we would set that aside if we had proof of actual innocence. But in reality, if you have worked hard to achieve a conviction, it is hard to let go of that for which you've put in a lot of effort. And it's also tough to admit that you were wrong on something as serious as a extended prosecution. And so it really, as I talked to several members of the office and leadership, they each kind of had slightly different answers as far as what they did and how they would handle things. And then I heard about a case where we had objected and gotten a judge to back us up on a case within the last 6 months of that, you know, so in 2016, where we'd said we didn't want to have some DNA tested on an old case. Well, of course, we ought to be open to having DNA tested no matter what the age of the case is. And so I realized that there was some disparity even within our office, just based on the arbitrariness of who would receive the petition or the information from the defense counsel. And so I think it's clearly best practice to put something this important in writing and have some clear protocols established. One of the things that was great is that we're not inventing the wheel. We've got a number of other district attorneys' offices around the country who have already done this, and it is tremendous how open each one of these offices is to having conversations with us and to letting us pick their brains. And so as we were formulating our protocols, we made a visit to Los Angeles, and Jackie Lacey welcomed us and then had her whole conviction review unit essentially spend the whole day going through an actual case file with them and talking about what their protocols were. We've been to Manhattan, we've been to Brooklyn, we've had phone conversations with a number of other jurisdictions. We're hoping to get to San Antonio. We were supposed to go in March. We're going to try to go at some point this summer. Folks that are doing this are more than willing to share what their protocols are and share what they've found in their best practices. We've talked to academics. We talked to Lori Levinson at Loyola in Los Angeles. We've come here, and John Hollway and the rest of the folks here at the Quattrone Center sat with us and spent some time with us and really talked us through. And so we got a good feel for what we felt were the best practices at the different jurisdictions from around the country. There are some pretty distinct differences. In Brooklyn, sometimes they'll do an investigation hand in hand with defense counsel. In some other places, we are told, hey, whatever you do, don't let a defense lawyer be a part of it, because the defense lawyer, their obligation is to their client, and what you want is whatever partner you have to make sure that they share every piece of information when you're doing the investigation. If the defense counsel has something that actually implicates his client, he might not be able to ethically share that with your conviction review unit. And so we were lucky, as we kind of have a slight hybrid of that, because when I came into office, I recruit people that have not only a demographic diversity, but also a diversity with regards to experience. And so one of the assistant DAs that I've hired in the last couple of years is a man who was a career public defender and was actually the head public defender in the city of Memphis for 8 years. And so by having him as the screener for our conviction review unit, we've essentially got somebody who understands a defense attorney's mindset as he is reviewing the claims and can screen out the appropriate claims. And then when that is, if it gets to the point where we are going to do a full new investigation into a case, it gets handed over to an assistant district attorney who has been a police officer, he's been a prosecutor, he's been a defense attorney for 10 years. I recruited him back to the DA's office, and so he is probably uniquely qualified to be able to do these types of investigations. And so by doing that, I've been able to kind of meld together a lot of the different philosophies and to be able to try to have a CRU that will be very effective and fulfill its mission. To me, that's been probably not necessarily the biggest surprise, but one of the unanticipated parts of putting together a CRU is how willing people are from around the country to share their experiences, their best practices, their version 1.0, 2.0, 3.0 to where they are, so that we don't have, any prosecutor's office around the country that's thinking about starting one of these, not only do I think it's best practice, but they're going to have a lot of help. And because we all recognize that as prosecutors, we all have the same responsibility to our communities, everybody's willing to try to help whatever community comes to us to say, hey, what are y'all doing and how are you doing it?
So you said something in there that I think is really interesting, and I'd like Mike to maybe ask you to build on a little bit. Not only having the experience of starting Dallas, which I don't know what version Dallas is on now, as they've gone through a couple different DAs and CIU heads, but certainly you were Dallas 1.0. And now in your defense role and with the Innocence Project of Texas, you work with, I think there are 5 in Texas right now. Is that Harris, Bear, Dallas, there's Fort Worth, Tarrant. I feel like I'm missing one.
Maybe Travis.
Could be. Anyway, you're working with a group of them in Texas. And one of the things that Glenn said is, Brooklyn says, let's engage and embrace defense counsel and bring them in with us. And we know there are other offices that kind of work at arm's length. So, from your perspective, having run a unit and now on the defense side, how do you evaluate the sincerity of a unit? How do you know when you're dealing with a unit that's good or where you have trouble? What can units do to work productively with you, and which of those models do you think is good? And I might tack 2 or 3 other multiple questions onto that single question just to make it hard for you to answer.
Well, I can really only address my experience and in my observations, and I think whether the defense bar is, we're a skeptical lot, and should be. And so I think whether the defense bar is buying into whether this is a real conviction integrity unit or a conviction integrity unit in name only is the results, really, quite simply. Because I think the results speak louder than any of the words or actions of any newly formed conviction integrity unit. Because, in Texas alone, there's, my understanding is well over 100,000 felony convictions a year, not to mention the over 100,000 prisoners who are locked up in Texas prisons. So whatever percentage or part of a percentage of wrongful convictions you use, that still adds up to a lot of innocent people that have been wrongly convicted or in prison. So the wrongful convictions are there. And if there is a conviction integrity unit and it's not finding those wrongful convictions and effectively remedying those wrongful convictions, then I think the defense bar and really the public at large is going to see them as a conviction integrity unit in name only. In Dallas, we had a unique situation in that, and really it made it easier for us in some ways, in that when Craig Watkins got elected in 2006 as the district attorney, he was an outsider. He was not elected as someone from inside the office. And he had never worked in a district attorney's office or as a prosecutor. And he'd never held a public office before. He'd never been a judge or anything. So we had we didn't have the ties to the old administration that say a district attorney, which is what I understand the Los Angeles situation is, where a sitting district attorney decides to form a conviction integrity unit. And so when Craig hired Terry Moore, a defense lawyer, at least at the time, but who had experience prosecuting and in politics, as his first assistant, and then they made the decision to hire me to be the Special Fields Bureau Chief and to start the Conviction Integrity Unit. I think that I think that was the start for building credibility with the defense bar. And then as we started getting the results, I don't know, the media always wanted to know what's the exact number. We had over 20 exonerations in the 4 years I was there. And as we started getting the results, then there obviously was the buy-in from the public and from the defense bar. I think that, and the really tougher question for someone or a unit that is in our situation is how do you get the buy-in from, if you will, from the holdovers from the old administration as to what you're doing. And, you know, when you've got all new people at the top and they're, you know, used to doing things the way they've done them. And once again, I think, you know, you start out, we started out with, you know, the premises and mission statements that, you know, that in a way are self-evident and no one can argue with, such as we see ourselves as protectors of the public safety, and convicting the wrong people in no way, in many instances, letting the real perpetrators go free is in no way protecting the public safety. And under no circumstances can that be said to be protecting the public safety. You know, put another way, our mission statement was to convict the people who are guilty and exonerate the people who are innocent. And so, notwithstanding that, you know, I think what the defense bar, the public, has to see to really have buy-in with what we're doing, they have to see the Conviction Integrity Unit, or whatever they're called, willing to do the right thing even when it is politically risky, even when the police might be upset about what you're doing, even when the law and order red meat voters might be upset at what you're doing, even when the victims advocacy groups might be upset at what you're doing. That if you're willing to do the right thing in the face of all that, then I think that the public at large and the defense bar understand that you're a real conviction integrity unit, not motivated by politics or protecting professional reputations or things such as that.
So there's an awful lot in that answer, which we could sort of unpack, and I deserve getting it all because I asked it all in my questions.
I'm not even sure I answered your question.
But let me turn to the three of you and sort of say, without any particular one of you, you know, being first or second, but you know, what do you do to get that buy-in from your internal constituencies, and which, you know, Mike talked about both buy-in internally and buy-in with the defense bar, and they're skeptical for different reasons. So, you know, couple that with, I'm sure that there have been cases, Mike, where you've been on the other side and had just a reasonable disagreement on the merits with a defense counsel when you're in the CIU. So factor that into the complexity of this, and how do you guys convey that sincerity and build those relationships both inside and outside your shops?
One thing I noticed, to answer one part of that question, is that everyone here, outside of Mr. Valdez maybe, built their conviction review or started with the idea of diversity of experience. And I think that truly helps with the buy-in externally with the defense bar, with innocence projects. And maybe some don't have the, outside panel to review conviction review too. That just wasn't something I thought we could take on right now in our office. But having people with defense experience on the conviction review panel seems to be working, and I think would enhance the buy-in. So some of the defense attorneys here in the office know that I was a defense attorney for 20 years. And yes, I do still think, one part of my brain is still thinking like a defense attorney. And I think that helps with the diversity of experience as both the prosecutor, what my current role is, and what I know from my historical experience. And together, that gets to some sort of idea of fairness. And if that is shown to the public at large and anyone else, it helps with the buy-in.
No, I definitely agree. I mean, one of the reasons with our first chief, he had extensive criminal defense experience. The current chief actually started his career as a criminal defense lawyer working with Jerry Goldstein. I do think that helps send a message to the criminal defense bar that, hey, this is not a prosecutor who's looking to prosecute cases. But the other thing is, I mean, and you brought up a really good point. I mean, it's tough, and Mike was talking about it, politically, sometimes, we focus on the exonerations and the folks that are actually innocent. But lots of people that are getting relief, they're getting relief for, procedural violation, a constitutional violation. And, that is where we see that we have frustrations within the office. We have a case currently, it's an intoxication manslaughter case. And, the evidence is very strong that, the defendant did it. Her defense attorney, she alleged, had, basically forced her to engage in sexual acts as part of the representation. As we investigated those claims, we discovered not only was that true in her case, it was true for several of his clients. And we've actually indicted that lawyer and have those, that prosecution proceeding. But that means that this woman did not receive effective assistance of counsel. He was operating under a conflict, and she's entitled to relief. That means his conviction is going to be set aside. Now, it doesn't mean that we're not going to probably go forward on the conviction in the future. It's tough to sit down with the family of the victim and let them know that this is what is the right thing to do. It's what the law requires, and we have to do it. And it's difficult to sit down with the prosecutor who had worked on that case and tell them, hey, guess what? We're starting from square one on this case. But it's the right thing to do, and it's what we have to do. It's what protects the integrity of the system for all of us.
I think there are really three constituencies that need to understand that a conviction review unit is being done in good faith, and that it is being done for all the right reasons, and that it is a real conviction review unit. Number one is the Nashville community. The entire Nashville community needs to understand what we're doing and why, and as we roll this out more publicly over the next few months, we're going to make sure that the community understands that as a prosecutor, I think what's most important is that, number one, we keep the community safe. Number two, that we keep the community healthy, whether that's dealing with mental health issues or substance abuse issues. We need to make sure that the community is healthy. They're on the individual case-by-case individual basis, but then thirdly, that the system's fair, because only if the community sees it as fair is the law enforcement in the community a healthy community. So we need to make sure that anything that we can do to make sure that the community understands that we are being fair and that we are doing our part to make sure that we have the right people occupying the prison beds in Tennessee. The Nashville community will embrace that if we're doing this the right way. Secondly, we do have to make sure that the defense bar understands that this is not just something for show. We're not just giving lip service to saying we're open to these types of new information that might indicate actual innocence. That is important because the defense counsel have an important role, but they also need to understand that we're dealing with them in good faith. And then lastly, and just as importantly, is there has to be buy-in from our office and from law enforcement. Because if I do not want to send any of our prosecutors into court to do the hard work that is handling these cases, using the discretion, talking to the witnesses, supporting the victims, going to court, convincing a jury to convict, convincing a judge to sentence. I don't want to send them in there feeling like they are standing on sand. They need to know that we are going to support them in their efforts, that I'm going to support them in their efforts, and we're going to back them up. But on the situations where later on, despite what they knew at the time that they did their trial, their charging decision, their conviction, taking their sentencing position, if we find out some new evidence, then and only then will we take a fresh look and essentially do a brand new investigation to see if we still have confidence in that conviction. But it's important for the office to understand that, and so it's important not just to have folks who have criminal defense experience, but to have some of the toughest prosecutors in our office be a part of this team. We have people who, like the person that's going to be in charge of the investigations, who's a former police officer, who no one would say, well, he's somebody who has a way too defense-oriented bent. I mean, he is a tough prosecutor. Some of the other prosecutors, I've got another former police officer who's been a career prosecutor and has never done criminal defense. He's on the team. I've got a woman who's in charge of our violent crimes unit that nobody in Nashville would say is anything other than a hard-nosed prosecutor. And yet these folks are also fair and they are open to this. They have fully embraced it. They came on the trip and actually met with the folks here at the Quattrone Center and with the folks up in the in Manhattan and Brooklyn. They are open to this. And then when we had our office staff meeting where everyone was in and we explained what we were launching, why, I went over the protocols with the entire office. When the office looked and saw the panel of folks who were going to be in charge of that, there was some reassurance in there that, okay, this is not a portion of the office who's going to be an internal affairs unit. This is not somebody who's going to be constantly attacking our work. This is somebody this is a group that is, if anything, going to enhance our reputation to where when we go in front of juries and we speak to the media and we talk to judges, they know that we are the types of folks that are only going forward and persisting in cases when we are convinced beyond a reasonable doubt, and we maintain that level of certainty on our cases. So for all those constituencies, that's why we put together a diverse group.
So there's another theme that Mike brought up that I'd like to tease out a little bit more on, and that is the sort of linked concepts of the use of exonerations as a metric for success, and the idea that there are a sufficient number of errors in the system just by the kind of the law of large numbers and volume, that if you're not finding them, you're not looking hard enough. So yesterday, one of the things we heard when we were doing the forensics conversation was that it wasn't so much that there were more errors in Dallas, it was that Dallas was better at preserving their evidence. And so that's what enabled the 20 exonerations, and in fact, I think kind of to Mike's point, there were probably the same rate of errors in other jurisdictions, but it was harder to follow up on them because there was a sort of a cache of evidence. Now, Mike's making a frowny face like maybe he doesn't agree with me, so let me pause there.
No, I mean, I'm not disagreeing with you. I'm just saying, having been there.
Which does give you some credibility here as opposed to me.
I guess. But no, we only found the evidence in, I do believe that Swiss did a better job of preserving biological evidence than maybe any crime lab in the country. But that said, we only found the evidence, in maybe a third of the cases. I think there's an erroneous narrative out there that all we did is, okay, you're innocent. Well, let's go find the DNA, crack open the sexual assault kit, and test it, and we'll just find out. I mean, there was a whole lot more to them than that. I think more than certainly the good job that Swiss did in most of the cases was very helpful. But I think what was really more telling or more effective was our proactive attitude that we did want to find out the truth. We were going to look for the evidence. I mean, I can just, as one example, we had a high-profile murder exoneration that when we were looking through some of the old cases where the defendant had asked for a DNA test and had been refused a DNA test, I found a case where the notes on the database were, this would be a great case to DNA test, but Swiss has lost the evidence. And then after that, the judge dismissed the whole application for DNA testing because Swiss had lost the evidence. And then I found out after that, there's a note, Swiss has found the evidence. And then for a year, nothing had been done on the case. And
I'm sorry, Swiss is your lab?
Swiss, it's Southwestern Institute of Forensic Sciences. And so that case moved to the top of the list to test, and it turned into a high-profile exoneration that actually 60 Minutes covered, which is another story.
So, okay, so to this point, how do you guys evaluate, and especially now that you're modifying the structure of your offices, how do you evaluate success? What are your definitions of success? Exonerations presumably is a metric.
I think we would all love to have the high numbers of exonerations, and we will be working to get to that goal as well. But I think a better metric of success might be the number of cases fully reviewed and the amount of open dialogue we have with the defense attorneys, the Innocence Project. So it's that open process, the accessibility, the transparency that starts with the buy-in, and then the metric of success will be, does everyone feel that we are working towards the right goal? So the end result will get there, but right now, starting forward, it's just that we have the process, we have the open dialogue, we have the procedures, if we work together to go interview a witness, so that we do all that, and that is the first measure and the first step towards the end goal.
Yeah, I think, one of my concerns is, I don't like trial prosecutors who measure their success in the number of convictions. I think it creates an incentive that the most important thing is that I get a conviction, and I think that's where you end up having people, not doing what's just, not doing what's right, taking the easy way, because, the state has a lot of power. I mean, we can prosecute people. And so I think focusing on how many exonerations we have can create the same kind of incentive to take shortcuts. I think the better way to evaluate it is just like she said, the number of cases we've reviewed, our confidence in what happens one way or the other, whether we validate the conviction or whether we get someone relief. And I think if we take that approach and that focus, the exonerations will come.
I agree with all of that. But I'll say this, that the one thing that we believe, being, I think, the first and being under a microscope and having a lot of skeptical eyes looking at us and what we were doing, the one thing we were very careful about and knew could basically undermine everything we were trying to do would be to exonerate the wrong person, to vacate a conviction that could not be clearly supported. Because, frankly, there were a lot of people poised to jump on us the first time there was a hint that something like that had happened. So there is just as much of an incentive to be careful and to do the right thing and not to take shortcuts, because all of these exonerations are closely scrutinized, and it undermines. It would have undermined the credibility of all of the exonerees who deserved it had we, quote unquote, exonerated a questionable case or exonerated the wrong person. Which, frankly, there were a lot of people in Dallas that wanted to see that happen, so they could point the finger at us and say, what these crazy people are doing is completely wrong, and they need to go back to putting everybody in prison and let the defense bar do their job.
Well, first of all, I don't know 100% about what our unit's only 4 months old at this point, but I have to not know exactly what's going on whatever cases they have already started to field, because I can't be part of the process of doing the investigation. When the investigation is complete, then I will be presented with a report, and then it'll be my call on whether or not to vacate the conviction. But we have put certain safeguards in where I will be getting, they will be meeting on a monthly basis. I will be getting an annual report about how many cases they reviewed and how many of those cases went on to a full, fresh investigation. And then obviously I'll know how many, if any, actually get on my desk for me to make a decision on. You know, it's one of those things where in some ways you say, well, gee, I'd like to have some exonerations, but on the other hand, you really don't want to have any exonerations because you don't want to know that we unjustly incarcerated anybody for a substantial period of time. So what is the metric that you use? I think it's going to be hard. It's not going to be the type of statistic-driven metric that we would like to see, say, when we're trying to drive down our numbers of dismissed for failure to prosecute domestic violence cases. Right? Those are, you know, we know how many warrants get taken out. We know how many can be successfully prosecuted. We know how many folks are into counseling and are working toward getting into healthier relationships in a domestic violence case. But this is going to be something it's going to be harder to have a hard number of, are we being successful? I think we're going to have to measure the success based upon how well are we doing with our reviews and with how much buy-in we have from the community, from the defense bar, and from the folks in the office that we are in fact doing our job and attempting to make sure that nobody is in jail that doesn't deserve to be in jail. You know, beyond that, I think we will measure our success based upon when we do have to make an exoneration, if we can really find best practices so we know why we messed up, and then we can train within our office and then with our other law enforcement partners in order to make sure that those errors don't happen in the future. If we can, at the end of this, say, well, because we had a CRU, we've been able to find that these policies or these procedures need to be updated, need to be brought into 2017. We don't need to make these mistakes. We need to have whatever checklist or whatever cognizance of a potential issue. If we can improve the administration of justice, then that's a success for the CRU as well.
So, yeah, and one of the things that we have said in our report, and that I say to reporters a lot, because we get calls from reporters who want to know what's the best unit, and we talk about the complexity of that, and then they say, well, who's exonerated the most? And there are, the Brooklyn unit, for example, was really founded because they had a police officer that the office had decided they needed to review all of his previous cases, and so they knew they had a bed of 150 or some odd cases that they were going to have to review. Not all the units that get created have that sort of bolus of cases to review from the outset, which might make it harder to have exonerations be a near-term metric. So I think that's one of the challenges with that, and appreciate your guys providing some more context there. Mike and Rico, I'd like to talk a little bit about the San Antonio 4, because I think that's a case that you guys were on opposing sides of, or maybe the same side but opposing roles of. I'll let you describe it. That I think really underlines a lot of the complexity of the role and the relationship between the DA's office and defense counsel in these cases. And so I'm hoping that we could maybe do 5 minutes on that and how you guys handled it, and then maybe we'll open it up for questions and see where we go from there.
You want me to start?
I think so.
Well, certainly there were a number of complex issues in the San Antonio 4 case.
You might need to give like a 2-minute factual summation for the audience.
Sure. In San Antonio, Texas, 1994, there were 4 very young women, some were in their late teens, some in their early 20s, who had recently come out as gay. And keep in mind, this is a very conservative community in 1994 in Texas. And they all came from strong family backgrounds. They all had none of them had any criminal history. They were all working. One had actually started school at Texas A&M, hoping to become a veterinarian. But they were all friends. I mean, that's kind of what they had in common. They really, didn't have. I mean, they had other friends, etc. There was no particular thing that bound the four of them together. Long story short, they got accused of sexually assault, basically gang raping, the four of them gang raping two young girls that supposedly happened, depending on which story you believe, supposedly happened July of 1994 or August of 1994. And all four of them were ultimately convicted. It was two different trials. There was a lot of homophobia involved, I believe, in the investigation. There was even some talk about satanic ritual abuse, although that did not play a huge part in the trial itself. It was, to my mind, an inherently preposterous allegation. The issues were pretty cut and dried in that I think either this happened or it didn't, because although the stories diverged quite a bit among the two quote-unquote victims, all the stories agreed on is it was all four women, both girls, at the same time. So it was kind of the deal, if one of the women is innocent, then they're all innocent. If it didn't happen as to one of the little girls, it didn't happen to either of the little two girls. So, in investigating it, we uncovered the motivation, and one of the two girls who, was in her, I guess, well into her 20s by the time, she was 7 at the time the accusations were made, was well into her 20s by the time we got the case of the Innocence Project, recanted and said, this did not happen. It did not happen to me. It did not happen to my sister. I would have known if it happened to my sister because under everybody's story, we were both there together when it happened. It didn't happen. It didn't happen as to one of the four and not the other. It just didn't happen. And pretty much explain the evolution of how this whole false accusation came about. And so there was that. But the other alleged victim remained quiet. Did not come forward and recant, and it's my understanding, maintain that it did happen. And obviously they can't, under the facts, fortunately in a way, they couldn't both be right. You couldn't really parse out part of the crime and say, well, it happened this way with, But, and then added to that was we discovered that the state's expert, who, still is, I think, testifies regularly for the state, a pediatrician in San Antonio, testified erroneously as to her physical findings of sexual assault. And that was huge at trial because the stories at the two trials, the stories of the alleged victims were all over the place. And that's easy. The inconsistencies in the stories are easy enough to write off as, well, they're children. And particularly if you've got physical findings or supposed physical findings of sexual abuse testified to by an expert, a doctor in this case, a respected doctor in this case. And so, I mean, the jury's kind of left with, well, somebody sexually assaulted these little girls, and they say it was the four lesbians. So she, to her credit, recanted in an affidavit her trial testimony and said, that's what we thought back then, back in 97 and 98 when the actual trials took place. But we now know that what we saw, or what I saw, or thought I saw, what I told the jury I saw, are actually normal variations that occur in young girls that are examined in which there is no allegation or no suspicion or no reason to believe that there's sexual assault. And in fact, what we saw normally occurs in young girls and is not, as we believed back then, physical evidence of traumatic injury. So that's in a nutshell what the case was about.
Yeah, Mike came and met with me and sort of laid out his belief and his opinion of the case. And I think the initial problem was I wasn't sure that Mike was trusting me that I wanted to do the right thing on the case. But I tried to reassure him early on that he would have full access to every file, every document in the state's file, and that I would start investigating the case myself. And you know, I know the prosecutors that were involved personally in the original trial, and I honestly don't believe homophobia, anti-gay bias played any role in their decision to prosecute the case. What I think was it was all based on the scientific evidence. Everyone I talked to, they're like, this doesn't make any sense to us. In fact, that's the whole reason that you had the satanic ritual notation, is the facts of the crime don't make any sense. But we had what we thought was solid scientific evidence. And it, you know, when presented with two girls that are saying this happened, we've got evidence that confirmed it. I understand why they prosecuted the case. So first thing I did in the investigation, I reached out to the doctor who had done the original examination, and I asked her if she would be willing to re-examine her findings, because I knew the strongest evidence we would have on the scientific front is if the original doctor is saying, I no longer stand by my original conclusion, I don't think it gets any better than that. We don't have to have competing experts. And to her credit, she was willing to re-examine it. Her original opinion was based on very limited studies that were not scientifically valid, that basically said this, when you see this type of marking on a hymen, it's an indication of an injury that's healed up, so it's a scar. Based on studies subsequent to her testimony that she's aware of now, she was very forthcoming and said, no, I would not have that same testimony today. And so that, for me, sort of really changed the nature of the case. And I knew at a minimum level, we were agreeing that all four of the women should get new trials. But then, you know, the harder question is, what about the exoneration? And that's where, you know, I was conflicted, because I had, as part of my investigation, met with the older victim, and I shared this with Mike, I found her completely credible. I also know, because of the science of memory and how, you know, your memory can be tainted, she could be 100% convinced that this happened, pass a lie detector test, and it didn't necessarily mean it happened. And so the approach we took going forward, and Texas is kind of unique. Mike and I can't just go before a district judge and go, hey, we've agreed to relief, you know, everything's fine, they're exonerated. Our high criminal court, we have split our criminal court from our Supreme Court, gets the final say-so on all of these types of cases. And so we have to make sure that we have a sufficient record. And so the decision our office made was we were not going to contest any of the defense's evidence. They were going to be able to put on their full case. And I'll tell you, it was a little hard because there were some things that were objectionable, but we sat there quiet. It's hard as a lawyer when you...
You mean like the past polygraphs?
The past polygraphs, exactly. But I decided... And we did get a slight note in the opinion that the Court of Criminal Appeals was not going to consider those because they're inadmissible. But yeah, whatever the defense wanted to put on, we were going to let them do it, because I felt that was the only way that the truth would ever get out there.
So how do you balance a situation where you believe they should get new trials, but you also have a credible victim, and you're dealing with both the community's perception of that, the victim and their family, and in fact, now you've got a split family, right? Because the the two young women were sisters.
Yes.
And so what was the position that the office took then on how to move forward?
We just, even though we would have had the ability to call the non-recanting sister, and we had an affidavit from her, we decided not to introduce that evidence at the hearing.
And so let's bring us home.
Oh,
Well, you know, in the, as Rico said, they agreed, the district attorney's office, Rico and the district attorney's office agreed pretty early on that because of the erroneous scientific testimony, that the four women should have their convictions vacated and they should be granted new trials, and then, you know, it would be dealt with at that time. What was important to my clients, and you know, just on principle, and of course, you know, there are other reasons as well, was that there be a finding of actual innocence, which Texas recognizes as a freestanding claim, and it sets a clear and convincing standard for of new evidence that establishes by clear and convincing evidence that they are absolutely innocent. And we believe that we had met that standard. We put on the psychologist who evaluated the recanting witness, who testified that the original charges had all the hallmarks of a false conviction, that she had looked at hundreds and thousands of cases, and that the recantation had all the hallmarks of a truthful recantation. We put on, I had, you know, each of the women sexually evaluated by, you know, the people who normally evaluate convicted sexual offenders. And she concluded that none of the women had any sort of propensity to commit this kind of offense. And then, you know, of course, knowing the women myself, I mean, none of it made sense. They were all, in my opinion, truly outstanding individuals who had weathered this grave injustice incredibly well.
can I interject for a second? Mike's leaving out a fact that I think is important to know. The women could have been paroled. One was, 3 others stayed in prison. If they had just voluntarily entered into, you know, the sex treatment program the prison offered, but that would have required that they admit their guilt. Yeah. And they weren't guilty. They weren't going to do that. And so, you know, that was one of those things that factored into how I looked at their case, knowing that they were willing to stay in prison rather than say, I did this.
Thanks. I mean, that is important. And then, so ultimately, the trial court, in Texas, the trial court just makes a recommendation where you file the writ, found that they were deserving of a new trial on the erroneous scientific evidence, but he found that we had not met our burden, our heavy burden of clear and convincing new evidence for an actual innocence finding. But he just makes a recommendation. And then it went straight to the Court of Criminal Appeals for what amounts to really a de novo review. They give some deference to the trial court's recommendation. And they found in 2 extensive opinions that we had in fact met that burden and that the women were actually innocent. So we got relief on both grounds.
So that brings Bexar County up to 4 exonerations.
First 4.
No, actually, we had one before that. That was earlier with our conviction integrity.
So 5.
So 5. So
But who's counting, right?
as long as I can keep it on one hand, I can count it.
So there's certainly more questions that we can go through, but let me pause and ask if any members of the audience want to ask any questions. We have, as we did yesterday, we have the microphones there, and I'd ask that you use those just because we are recording, so. Yeah.
Yeah, hi, John. All right. My name is Mike McLaughlin, and I just wanted to put something before the panel that it's kind of a newsflash to anybody that's from outside of the city, but we're actually a pretty corrupt city. So I was talking to Phil from Clark County, Vegas, yesterday about this, and it was a little bit of a joke because it's like running for which city's more corrupt. Our recent Attorney General was indicted and convicted. We currently have a district attorney in Philadelphia who's indicted, but not yet convicted. 10 years ago, I had a run-in with a corrupt judge. And I said this to the Innocence Project yesterday. I said, do not believe anything I tell you, because I have a bias, and I'm putting my bias on the table. There's a thing called Google, there's another thing called Bing, and another thing called Yahoo. And if you put the name Willis W. Burry Jr. into any one of these search engines, you're going to come back with, like, there's a prima facie case that this guy's actually right about corruption. This man, Burry, I call him evil because, to me, if you're a public official and you violate the public trust, your head should be knocked off, stuck up somewhere where the sun doesn't shine, and you need to do some time.
So can I just interrupt? And I do want to make sure we have a question.
All right, my question is, the district attorney's office of Philadelphia sometimes is obtuse, to put it in one sentence word. Burry was convicted. It's a fact that he's convicted. I litigated a PCRA recently, and the district attorney's office of Philadelphia. And when I say PCRA, people might not know what that means. It means Post-Conviction Relief Act. There's little caveats and nuggets, as any lawyer would know. You're supposed to present a claim in 60 days that a date could have been presented. So you could be innocent, and they'll say, wait a minute, you brought this claim forward 62 days after you knew it of the claim could have been presented. They'll say you're 48 hours late. You might factually be innocent, but you're time barred because you didn't act within 60 days. When the time says you have to act in 60 days, you act in 62. So these are little things that could drive the average person crazy. I litigated this claim in front of a former district attorney, and the guy still basically works for the district attorney's office, albeit he's a judge. You have to be fair, okay? And
So do we have a question coming?
my
'Cause I don't wanna
question is,
relitigate
how do
a
you get
procedural
integrity into the system when you have actual facts and the DA's office will say, listen, this judge is corrupt, we admit it. I mean, this is perverse that they're admitting the judge is corrupt, but they're saying this has been known since 2009 that the judge is corrupt.
Mike, if I can interrupt you, I know
Yeah.
we tried to talk before the panel, and
Yeah.
I got pulled away, so I'd be happy to talk with you and hear you out, but I know there are other people behind you who have questions about
Okay,
conviction
well,
review, so-
let me get this in, because my daughter is hurt by this man. She's 9 years old. Samantha is her name, okay? And this is collateral consequences of what evil people do. This judge is corrupt. Again, the name is Willis W. Burry Jr. Google, Bing, or Yahoo bring this stuff back. It's not like I'm a crazy guy making these fallacious allegations that have no basis in truth.
Thank-
So the question,
thanks
the
very much.
question is, how do you rectify this? Because this needs to be rectified, period. The man was committing crimes.
So I think what we'll do is we'll need to talk to you afterwards, because rectifying an individual case is different from the concepts of rectifying sort of more generally, and I think,
Well, okay, let me
AD
ask
Martin
one
will talk to
question
you
you
afterwards.
could probably get answered. Can there be PCRA reform that when you prove a miscarriage of justice happened, that the DA's office would say, listen, we don't care if you're 65 days after you file this or 67 days, that's 7 days over the time limit, but it's a miscarriage of justice. Can there be reform in the PCRA Act that you could just bring forward a claim without time bar on it?
So PCRA reform is a great topic, but it's not the topic of this panel, and we can, again, discuss that afterwards. Steve?
I'll just ask about apology. One definition would be a statement of remorse, regret, and responsibility. Do you think there should be, in the cases of exonerations, either official, institutional, or individual apologies? And if so, should there be any remedy attached to those?
You know, like I say, I can only talk from my personal experience, and this is sort of responsive to what you're asking. When Craig got elected in 2006 and then took office in 2007 in Dallas. Craig Watkins, the DA. To my knowledge, Dallas County had, I believe, at that point, 9 DNA exonerations, and was certainly, even at that point, was one of the leading counties in DNA exonerations. But I think each one of those were looked upon as an embarrassment, and by that administration, even though some of those went back many years, and they were kind of ignored, I think with the hope that there might be a flurry of media coverage, then it would go away. When Craig took office, he owned the exonerations, which was something that was kind of new. He went in and he publicly apologized to the individual who was being exonerated. And I believe that was something new, and something that really had not been considered before by the previous administration. And then, of course, I guess that took hold after that. But that's more of an informal, procedure. But he did make it a point, and I think it was very important. It made a lot of difference to the exoneree to make a public apology there at the exoneration hearing to the individual for what had been done to them, even though he himself had really had nothing to do with it directly.
I think with regards to apologies, certainly in many states, I know in Tennessee, if it's not just vacating the conviction but determination of actual innocence, then there are procedures that can take place to get an apology in the form of a monetary amount. Of course, no monetary amount could take up for someone losing 10 years of our finite time on earth. But that is at least kind of a tangible step beyond just the fact of an apology. There are cases like when the science changes over a number of years. We heard about a case from New York where a man had been convicted of arson, and the science of arson had advanced while the man was in prison, and now the same expert was able to say, well, actually, we determined it wasn't arson. And so their integrity unit was able to vacate and exonerate the person, but that was because of a change of science, not because of someone being a malicious prosecutor or a witness testifying intentionally falsely. But you're right, that is it's all a part of establishing that your name is cleared, trying to make sure that the collateral consequences don't continue to follow you, and trying to do something to give you some recompense for the amount of time that you've lost in prison.
Denise?
Hi, my question is about cost, and if you could just comment a bit on who funds you, how much, and whether you ever see your role at maybe expanding the coverage of the area that you have jurisdiction over. The reason is because some states have 56 counties, and having 56 conviction integrity units doesn't probably make very much sense, and I'm wondering if you look further along the line, if you might cover 10% of your time for a rural county, if you could just comment about some of those issues.
Well, I know with our office, we are territorially limited to our county. We don't have the authority to prosecute or investigate crimes outside of that jurisdiction. And as far as our budget, it just comes from the general DA's budget. It's whatever resources he wants to allocate to conviction integrity. But I think you make a good point. It's just, in Texas, and I assume in some other jurisdictions, that would have to be addressed by the state legislature and how they would want to structure and create it at that level.
Tennessee has 31 judicial districts that cover 99 counties because Nashville is Davidson County. We have a metropolitan government, so Davidson County is the largest county. Our judicial district is just our county. We are funded about $7 million from the state, about $6 million from local, and so we will only be doing Davidson County pretty much forever, I'm sure. Though with regards to the fact that we will be the only established conviction review unit in the state, we have an association of district attorneys across the state that meets very regularly. And, as we have ours put in place and see some progress with it, then I will be sharing all this with my fellow district attorneys, and I'm hopeful that some of them, or maybe all of them, will adopt similar uniform practices.
Hi, my name is Anjali Srinivasan. I'm here from the San Francisco DA's office, and we're actually in the process of trying to think about and eventually set up our own conviction review unit. So I wanted to thank you all for all your insights, and I myself have pored over the Quattrone Center's report and looked at every detail, thinking about it, and it sounds like there are a lot of different stakeholders involved, and we've talked a lot about buy-in today. I was wondering if you could each speak a little bit about some of the unexpected challenges that you may have faced, something that you didn't think was going to be a problem, or a group or agency that you didn't expect to either be an obstacle or maybe even an ally in all of this.
Go ahead.
None of you had any unexpected challenges?
I barely got here this morning, so my days are unexpected challenges. Actually, I have been surprised how receptive law enforcement agencies have been when we're asking them to go out and, re-examine, re-look at certain things. In the San Antonio 4 case, when I talked to the detective that originally investigated the case and took the reports, I expected him to say, it's 15 years ago, I don't know anything about this case. He was very forthcoming and was not at all defensive, and I appreciated that because it made it easier for me to do my job. But Bexar County may be a little unique in this respect because we sort of had our big scandal with our crime lab back in the late 80s and early 90s, and they did a lot to clean it up, and so I may be unique in that situation.
Again, we're relatively new. We haven't run into any major roadblocks. I think everything that is a problem out there, hopefully we have thought about it. We might not have it braced it yet, but just the other day I walk in and everyone in the unit is sitting around looking very morose, and they're already contemplating what are we going to do when we have to tell the first victim who's insistent that this happened to them that we are going to make some sort of relief, and just the working with the victim advocacy groups and trying to figure out that process. This whole procedure, the whole thing, is gut-wrenching from both ends, from all parties, from all perspectives. So I think it is an emotionally draining but also exciting time. And we're just going to hit, no roadblock, no distraction will take us away from the ultimate goal.
Yeah, everything that prosecutors do, everything that courts do is all about, let's try to make sure that we have finality on our convictions. We don't want to continue to litigate the case that happens today for the next 100 years. And so this cuts against a pretty well-established grain when it comes to the way prosecutors think about what they're trying to do and close files and make sure that they can finish that case. And, post-conviction relief should not go on forever, and many states are shortening the time period where people can make applications for post-conviction relief. So this does, in fact, cut against some of that grain. On the other hand, in Tennessee, we have a Tennessee Supreme Court Rule 3.8 that pretty much commands us to, if we are presented with evidence of actual innocence, that we are supposed to do whatever is necessary to correct that. And so what we did is we got in and we're doing the work on the front end in order to make sure that we are being able to message this as we're doing what we've already been commanded and what everybody would agree a prosecutor's role ought to be. That still is not going to make it any easier to bring in the victim's family and say, listen, I know that you were told, hey, we caught the guy. Yeah, we're going to prosecute the guy. Yeah, we got a conviction. And yeah, he's never going to get out. And now we've got to tell you that we think we've got the wrong guy in prison, and your heart's going to be broken all over again. The scab, that scar is going to be ripped wide open all over. You know, in Los Angeles County, they did a pretty high profile, they vacated a murder conviction, and that was a case that had been tried 3 times before they were able to get the conviction, and they finally got the conviction, and the man was sentenced. And then new evidence comes out, and they had to vacate that conviction. And one of our questions when we were meeting with Los Angeles was, well, at what point did you bring in the victim's family and let them know? And it was at the time when they got to the point where they were really starting a fresh investigation so that it wouldn't hit the family like a ton of bricks after they'd already made any conclusion. But that hurt that family so badly that they came on TV, one of the 2020 or whatever news programs did a episode on that case, and you know, they were saying, well, we heard it's because our district attorney wants to run to be on the Supreme Court, or we heard, you know, and so you can't blame them for having that, their hearts broken, and to voice those types of hurt, and because in their mind they'd already, this case was done and they were finished and they'd gotten justice for their daughter, and now all of a sudden the same people who had supported them for the years are telling them that you don't have justice, and they're like, well, how can they let him out of jail when they don't have somebody else that they're going to arrest right now? And I mean, you know, my heart breaks for him watching him on TV. My heart broke for him when I was being told about it in that meeting with the LA County Conviction Review Unit. That's going to be a real challenge, and you know, like everything else, have as much empathy as possible, but at the same time, we've got to do what's right, and that's why we take these jobs.
So we are technically speaking out of time, but I know a guy here at the center, and so I think we have time for 2 questions if we can be quick, and we'll start over here.
Okay, I thank you to all of you. I'm at an innocence organization and have seen firsthand that, you know, prosecutors who make the decision not to fight a conviction sometimes do face repercussions among their colleagues, and so those are really hard choices. And I think conviction review units have done a great job of kind of institutionalizing the idea that that can be the right choice. And my question for all of you is, a lot of these units have been established by really, you know, thoughtful, charismatic leaders. And what can you do internally to make sure that the cultural shift brought about by forming those units kind of outlives the people who form them?
So we're speed round here.
Well, again, I think that's why we're planning to rotate as many prosecutors as we can through the section, because each one of them will sort of be the seed that goes back out into their respective divisions.
I think, I like the idea of rotating, but longevity too, and just honesty and openness is, I think, very important.
Yeah, it's a real threat, but I've got an 8-year term. I've got 5 more years left. If I'm lucky enough to win, that's at least 13 years to try to entrench it in a way that will succeed long after I'm gone.
After the charismatic leader currently in office
Well,
has stepped aside.
I don't want to say. At least after the
You know,
current is gone.
Dallas is a real test tube for that question, because since Craig lost, he won re-election the first time and then lost the second time, and then that district attorney was replaced, was basically forced to resign, and the soul, if you will, of the conviction integrity unit is really at issue now. And so it will be interesting to watch to see what the current district attorney does with it. I don't have an answer for your question, but we'll see what happens in Dallas.
Last question.
Thank you. My name's Dan Stevenson. I'm head of the homicide unit in the Philadelphia Public Defender's Office. And Mr. Ware, you can count me as one of the ones who are more than a little skeptical about conviction review units, particularly here in Philadelphia, seeing as how last August our office saw fit to re-prosecute a man named Anthony Wright, who was in prison for 25 years after it was verifiably shown that he could not have deposited the sperm in the 77-year-old woman's vagina and rectum. The jury took about 7 minutes to find this guy not guilty over lunch. This case evidently was reviewed in the Philadelphia District Attorney's Office, but they decided to go ahead. That's just an aside. My question is for Ms. Martin. My unit is currently dealing with 3 separate habeas cases that came back, all men that were on death row, that their cases were sent back for multiple Brady, Bruton, and other violations. And your office has decided, after 25 and 30 years, to re-seek the death penalty on these men. What meaningful review process is in place, and what meaningful justification can there be for seeking the death penalty in these ancient cases?
Thanks for your question, Dan. I think the first words out of my mouth of the panel was that we're always open to reevaluating and review. What happened in August, hopefully, won't happen in September and October, November. We have internal capital case review committees. We have cases that come back from the federal courts for review as a committee to determine and then present up what should happen with that. So whenever someone else is new is in charge, there will be also reviews. There can be periodic reviews. There can be re-reviews. You send me a letter, our office will take another look at it. Anyone who calls me up and asks to take another look at it, whether it be for juvenile lifers or whatever else, I agree that we will take another look at it. So we're happy to do that in those cases.
And anybody you have currently that are prosecuting for death, will you allow those people to plead guilty for life in prison without parole?
I can't make any blanket statements, Dan. I'd be happy to talk to you about individual cases individually.
Thank you.
All right, well, please join me in thanking our panelists. This was really informative and much appreciated.